As people continue to come into the session, let me just say a formal good morning and welcome to everyone joining us today on this rather cold and wintry day in Joburg. I know that not everyone is here with us in Joburg, but with the weather being as it is up here in Gauteng, it's really an ideal time to warm your hands around a hopefully steaming cup of coffee or tea and settle in for an hour of practical insight and guidance on a very relevant matter affecting employment relationships across all South African workplaces. So let's get straight onto the topic of discussion for today. Let me just introduce myself, though, before that. For those of you who don't know me or haven't joined us in these sessions before, my name is Vanessa Botha, and I am the training manager of Conflict Dynamics and your host for today. So, recent constitutional and Labour Court decisions are sending a clear message to employers on the potentially intersecting topics of constructive dismissal and the handling of mental ill health. These topics are potentially linked because of the risk of a constructive dismissal claim where mental ill health is not appropriately handled by the employer. So, the question is, are you getting this right in your workplace? And to guide us on this important topic, I'm delighted to welcome Ibrahim Patalia. Ibrahim heads up the organization Mediate Works and is also a legal consultant at Cliff Decker Hofmeyr law firm. And he specializes in employment law, as well as also being a very highly respected mediator, arbitrator, facilitator, and a very well-loved and respected trainer for us at Conflict Dynamics. He integrates his experience in the practice of labor law and dispute resolution into all of these areas of practice. So just before I hand over to Ibrahim, just a few quick points about the session today. As always, an important part of these sessions is to provide the opportunity for your questions and your comments. So if at any point you have a question or comment which you'd like to raise, please just feel free to use the Q&A button or the chat function and type it up in there. And I'll be keeping an eye out for your questions, and we will try our best to respond to as many as possible in the time that we have available. Also, just to mention that a copy of today's slides, as well as a recording of this session, will be made available to everyone who has booked for the session, and we'll send that out via email within the next few days. So, welcome to Coffee with Conflict Dynamics, Ibrahim, and thank you for being here. We really appreciate it. We look forward to hearing from you, and so over to you.
Thank you very much, Vanessa, and good morning to all of you. Welcome to the session. It's really a pleasure to be with you. And of course, we've got this time together, which is valuable time. And as Vanessa indicates, please, we'd like to have your questions and comments. I notice colleagues on the session as well that are probably a lot more equipped in terms of this topic as well. So please feel free to share. Of course, the developments in respect of our law is continuous, but even as arbitrators and practitioners dealing with issues around constructive dismissal, and in particular issues surrounding mental health in the workplace, has become exceedingly more complex. One of the things that I recognize around mental health, I recently conducted sessions for a company all across, its divisions for its employees on DEIB. And I suppose, firstly staggered initially, and then afterward became quite intrigued by the whole impact of AI as an example, although this is not the topic for today. But what we discovered during the course of these interventions is the extent to which employees were using AI as therapy. And they were purposefully engaging with AI in a way that were dealing with mental health issues, and its consequences to workplaces have become even more complicated. The normal traditional approaches to dealing with mental health, while still effective, from an employer perspective, the advancements in terms of how people engage in with their mental health, how they find it and seek in support is becoming exceedingly difficult. And so while we are not on the topic of AI, mental health and mental well-being is quite an important topic for us to engage on. We are focused, as Vanessa has indicated, around the three important decisions that have come out from our courts just recently. And the one is Maleka versus Boyce NO and others, and that's a constitutional court decision. And that was issued on the 24th of February, 2026. And then the second is Lewis versus the CCMA and others, and that was a constitutional court decision as well of the 25th of November 2025. And lastly, the focus is going to be on solidarity on behalf of NEL versus National Meteorology Institute of South Africa, and that was a decision of 5 January 2026. I promise you that's as technical I'll get in terms of legal citations. We promise this to be quite practical. And when Vanessa asked me to speak on this topic, I was in myself understood these two, constructive dismissal and mental health, in isolation of each other, and the importance of recognizing its, I suppose, its consolidation and the complexity around this consolidation has become increasingly important in my mind, at least. The hope is that I take you through these decisions from a practical perspective, while zooming in not only on constructive dismissal, but on the complexities of mental health related issues and dealing with grievances that emanate from these matters within the workplace. And at the end is to hopefully provide a toolkit of sorts that would help any practitioner in a managerial role. Now, of course, constructive dismissal has been well established in our law. Constructive dismissal has three essential pillars, and those pillars requires firstly the employee to be terminated. They would have initiated termination of the contract through a resignation, and that's quite important. The second is that the continuation of the employment relationship in itself is deemed to be objectively intolerable. And thirdly, the employer is responsible for having made that particular employment relationship intolerable. Now, these three pillars, so to speak, have been accepted as part of our law and understanding of how we would decide if we were arbitrators a constructive dismissal matter. And these elements of the test have evolved and developed within our law over a period of time. And in particular, the understanding is, and typically, is that it is an extremely difficult case for an employee to prove. And this is an important component, unlike other unfair dismissals, is that in this particular case of constructive dismissal, is that the employee has the legal obligation or onus to prove the matter before an arbitrator that there was an actual constructive dismissal. Now, while that burden sits with the employee, it does not take away the responsibility from the employers to ensure that their risks are managed in such a way that the possibility of a constructive dismissal claim arising and their risks then of losing such claims at the CCMA is managed. In particular, where there are issues around mental health, mental well-being, discrimination that are linked, and they're often linked, to cases of constructive dismissal. These risks are not just about money that would be paid out to the employee, but it does involve the reputation of employees. Essentially, the standard that we have in our law has remained. The decision in Maleka versus Boyce is a particularly interesting one because it dealt with two components. One, it dealt with the component of what is this intolerability, and what should be the guiding test for intolerability. And secondly, it dealt with the issue around the utilization of grievance procedures before an employee can claim constructive dismissal. Now, in this particular case, Mr. Maleka was an IT director of a company, and there was changes within the company in terms of restructuring. He had initially, or as prior to the restructuring, reported directly to the CEO, effectively. With the restructuring, there was a manager that he needed to report to before the CEO. Essentially, his conditions of employment remained the same, that he was not paid less, his job description remained the same, and to a large extent, his title even remained the same. The main change was this reporting structure. And he, of course, wasn't very happy with this. And he was so unhappy and he was so persistent in this claim that he took this matter all the way to the Constitutional Court. He did not succeed at arbitration, the Labour Court, Labour Appeal Court, and then also did not succeed at the Constitutional Court. And now, of course, the courts looked at the matter with some levels of variance, and I don't want to go into all of the decisions of the Labour Court and the Labour Appeal Court or the CCMA Commissioner. But we'll focus on the Constitutional Court decision. Now, the Constitutional Court importantly drew a distinction between what is hypothetical or anticipated intolerability. Because in this case, Mr. Maleka said, well, there was no existing intolerability, but I could see it coming because I've shown my resistance to this new structure. Now, the court stressed that this intolerability must be in existence. There must be factual intolerability. There cannot be this notion that it would arise at some future date, possibly or possibly not. I think that's an important consideration. While there is this concept of intolerability, the factual conditions must be proven by an employee to substantiate that intolerability before an arbitrator or a court. And the court essentially set the test for intolerability exceedingly high, and I think for good reason, because it should not be some mere claim or allegation of intolerability, but there needs to be this real direct consequence and factual matrix that would support intolerability. And the conduct in question must be so severe that the employee cannot reasonably be expected to endure it. So any mere dissatisfaction or workplace tension or professional conflict common in any employment environment will not meet the standard. Significantly as well, the court ordered the court rejected this idea of anticipated intolerability, as I've said. Maleka, who was this IT director, resigned essentially in protest for what he had seen as an unfairness to him. And what we know that is a claim on its own. It's a unilateral change to terms and conditions of employment. And he had other opportunities to advance his concerns, both internally and externally, in terms of a unique case. And this was the second component of this case. The first being, of course, any assumptions or drawing inferences or as to the possibility of intolerability is not sufficient. The bar has been set exceedingly high. Then the second thing is that in this case, he did not use any internal procedures, and he did not deal with the matter that was, in his own words, was essentially a unilateral change to terms and conditions of employment. And this again was his undoing. What the courts found is that if there is a functional grievance proceeding, an employee cannot simply walk out because they feel that they are hurt. In fact, in the CCMA, the commissioner actually said that this is a dispute that is perpetuated by Mr. Maleka's ego more than any legal complaint. And so this is the reason why the court said that if there's feelings that are hurt or they anticipate a future marginalization, that is not sufficient. It is essential that the internal remedies are not bypassed for the simple reason that it denies the employer the opportunity to fix the issue. So in this case, there was no opportunity given to the employer to try and deal and address the issues and concerns of the employee. So two important points arise from this. One, the standard of intolerability has been set as exceedingly high. It needs to be factually proven. It needs to be in existence. It cannot be anticipated or potential or assumed intolerability. And secondly, the courts emphasize that the need to utilize internal procedures and remedies is of paramount importance. Of course, what we do understand is that in some instances, if those grievance procedures are unavailable or frustrated, or it's impossible to utilize them, that would create a variance. And we'll see in a moment that the other case that we're going to be dealing with, in fact, deals with this particular point, in that there must be, again, proven factual lack of confidence in the internal processes for an employee to then say, well, I could not utilize those internal processes. This was not the case here. So essentially, when we look at the, just in summary, I suppose, is that the employee's opportunity to utilize the grievance procedures, if they're not frustrated by the employee needs to utilize those internal procedures before resigning. If there is a dispute that is based on other factual details, like a unilateral change to terms and conditions of employment, and if the employee has not pursued that, while not an absolute bar, it would be important for the courts to consider this fact and for arbitrators to consider this fact, because it then undermines as well the potential remedies that the employee may obtain. But more importantly, it would undermine the very complaint of constructive dismissal. Now, I've included here, and the point that I'll get to a little bit later, is that there's a component of mediation, and it's something we would need to talk about as to what would be some of the tools that employers can utilize to enhance their internal processes. Just as a parting point now, is that grievance procedures themselves need to be advanced, accessible, and we see in organizations that have introduced mediation internally at that grievance procedure, and often I've been called into in workplace mediation disputes, those processes become a lot more effective. So just bear that in mind. It's an interesting point. While the courts have not said that, I make the point. So resignation must be a last resort. Now, if we keep that in mind, while there is now the standard has shifted, the linkage to this what we call the mental health or mental illness, and the potential trap that may exist when employees claim constructive dismissal is the pivot I want to make. And I want to advance this particular point of dialogue. Now, just to step aside from constructive dismissal for a moment and that linkage that I'm attempting to make, as I said in the introduction, mental health has become, I think, exceedingly important for organizations to deal with, not only from a legal compliance perspective, but we're finding that there is an exceedingly great amount of instances of mental health and medically diagnosed mental health issues within workplaces. The South African Depression and Anxiety Group found that 52% of employees have been medically diagnosed. And we'll make these slides available with all the references and resources as well to you. 52% of employees have been medically diagnosed with mental health conditions. The common conditions amongst those surveyed are depression, around 32%, clinical stress, 25%, general anxiety, 18%, and burnout, 13%. And I think all of us can relate. I mean, as much as I'm not medically diagnosed, I certainly feel burnout, the extent to which we have been working, even although I run my own business. I see this with clients as well, the pace at which people are working and the lack of care in terms of their own mental health and mental well-being. These statistics are staggering, and the cost to the economy is exceedingly high. I mean, the estimation is that 250 billion per year is lost in productivity due to absenteeism and presenteeism, meaning people are present, but they're just unable to function effectively within workplaces. And this has huge cost consequences, and it has greater impact to the GDP. I mean, you can Google the EAPASA report and research that they've done in 2025, and it's quite interesting, the findings that they've made. What's also interesting is that from this research, about 61% of employees, 61% of employees, of course, Canvas expressed a desire to leave their current jobs if they could afford it, citing work as a primary stressor. And 75% of employees were unable to switch off from work after hours. And there's more and more to this. And when we look at the data, it's not a small component that are being affected and impacted by the various levels of stress and mental illnesses that exist within the workplace. Now, from a legislation perspective, the Employment Equity Act, of course, prohibits discrimination against employees based on mental health conditions or impairments or disabilities. And the 2025 amendments to the Employment Equity Act has specifically broadened the definition of disability to include explicitly intellectual and sensory impairments alongside physical and mental ones. And so it broadens the legal umbrella, which in itself is, I find, creating levels of complexity, both from an affirmative action perspective and how do we manage mental health and mental illness. It includes conditions like depression, anxiety disorders, PTSD, and neurodivergence, examples of autism and people living with ADHD and ADD. Now, these are mental health issues that, of course, we're aware of, but from a business perspective, to fit that in employment equity, both in protection against discrimination and affirmative action, in itself can be complicated, and that's a topic on its own. The Labor Relations Act, in particular, protects employees against unfair discrimination and unfair dismissals based on issues around discriminatory basis, and that's referred to as automatically unfair dismissals. The Occupational Health and Safety Act obliges employers to provide a safe working environment, and this in itself clearly includes psychological safety alongside physical safety. And then lastly, the Code of Good Practice that we've seen introduced around the prevention and elimination of harassment also requires employers to take proactive steps to eliminate bullying, workplace harassment, which are major drivers in any event for poor mental health. So legally, there's a lot that has developed and evolved, and there's a lot of obligations in different ways for employers. And we also recognize the fact that the data and the statistics are indicating is that we cannot look away from this. The challenge, of course, for employers is distinguishing between what is truly a mental health issue, what is a misconduct-related issue, how do I deal with these issues? Because like all things that we talk about, there is an obligation on the employer to take responsibility and put into place mechanisms to deal with these things effectively. But there's also a counter-employee responsibility, but on both sides, they could fail in their responsibilities, meaning employees themselves could raise issues and claim certain things that create a sense of urgency, but in itself, there's no validity in these complaints. And we've seen this with the abuse of claims against on discrimination and, of course, mental illnesses and other forms of illnesses. I'm not saying all of it. There is this component, of course. Now, for employers, deciding how to proceed is an important component. Generally, what we find is, of course, conduct, misconduct deals with the employee's behavior, and capacity, ill health deals with the employee's ability to perform their job. Now, at times, of course, this can be difficult to distinguish. And so, we've got some guidance from different components of our law, but one of the cases, I think, well, it's 2013 case, ZA1 versus it's Nachi Clothing versus Goldman. It's a 2013 decision. So it put a very simple descriptor. It says that, well, for incapacity, the question should be, did the employee try but could not? Means they were trying. It's an ability issue, but they could not due to the ability, and they may require certain support. Versus in misconduct, could the employee do it but did not do it? Okay. And of course, those questions do help, but they're not necessarily the end all and be all. And so what we find is that in mental health issues, the complexity does arise where employees are, for example, taking sick leave, and there's a sense that the employee may be bluffing or lying, and they may be abusing the sick leave or time off, or their productivity may be lessened. And as a consequence, this may be seen as either misconduct or poor performance. Whereas if there is an adequate and proper diagnosis, it may well be that the employer has dealt with the issue as a conduct-related or performance-related issue, whereas it should have been dealt with as an incapacity, ill health issue. And so we need to understand that there could well be difficulties in managing these matters based on the path that we take. There are a range of cases that have dealt with this historically. The one is the legal aid case versus Janssen, and Abels versus the University of Stellenbosch. The courts noted that mental health is not always a justification for poor conduct. The onus remains on the employee to demonstrate a direct causal link between their mental illness and their inability to perform. So even though you may take an employee through a disciplinary process or performance process, and the employee then raises the issue, it would be their responsibility to say, well, here's the basis on which I have an illness, and that is contributing to the behavior. And then, of course, there needs to be a divergence to an incapacity process. If the poor performance, of course, predates the illness, the employee has been performing badly prior to them falling ill, it, of course, does not negate the obligation on that employee to follow the rules, meaning their performance was already bad. They cannot be using an illness that has occurred thereafter as an excuse for performance management that has already been taking place. The diagnosis of an employee as well is, once they diagnose, this is illness, right? Okay, fine. There's a process that needs to be followed, and we'll talk about that process shortly. But it is not an absolute shield for an employee, and this is an important component. They cannot raise this in every instance. There is, of course, a path that the employee would need to take to deal with their illness. There would be appropriate measures that would be put into place. And of course, the employee could still be held accountable for particular matters that occur, whether it's performance-related matters and conduct-related matters. What we find as well is, as soon as there's a diagnosis of ill health and there is this path, there's a sensitivity as well in terms of dealing with these employees in matters where they truly need to be dealt with through other mechanisms. Vanessa, I don't know if you want to put up a poll. We'll probably just take a short
Yes,
break and we
that's
go into the poll and hear some voices through the poll.
yeah, that's exactly what I was thinking we should do at this point. Um, I just having listened to those statistics that you were sharing, Ibrahim, I'm in full agreement with Londeka, who in the chat has said they're very alarming indeed. Um, so on that note, let's have a look at a question we'd like to pose to you. In fact, two of them that we'd like to pose to you in regard to how your organization or how you perceive your organization to be responding to employees who report mental ill health. So, firstly, have a look at this question and we'd welcome your responses. So, the question is, how confident are you? Oh, sorry, forgive me. Um, there we go. Is the poll up, Ibrahim?
Yep, it's up.
Excellent. Okay, so let's try again. So the question is, how confident are you that your organization responds appropriately to employees who report mental ill health? Let me give you a few seconds to respond to that. Let's see what people say. The responses are coming in thick and fast. Seems a few more people are wanting to respond. Okay, well, let's see what people have said so far. Let me share those results with you. Well, it's quite pleasing, Ibrahim, I think, to see that very few people, only two out of the 59 who voted, are not at all confident about how things are handled. But other than that, a very even spread, it seems, around how people feel about the responses that their organization is giving to mental ill health reports. Before I go on to the next question, do you want to perhaps comment there at all, Ibrahim?
Well, that's positive because, of course, a lot of what has been in place within our law, mature organizations have already embraced this in the interest of, their own employers and their own stability. So that's really heartening.
Great. Thank you, everybody that's participated. We'd like to share another question with you before we continue with Ibrahim's insights. So let me stop sharing that one and and go back to our next poll question. And this question speaks to how you see the responses happening. So the question is, which of the following responses have you seen when an employee raises mental ill health concerns? And we'd invite you to select what you perceive as the closest match of these options. So again, the responses are coming in thick and fast. Let's just give it another couple of seconds for a few extra people to respond should they wish to. Okay, well, we've got quite a few people that have responded there, so let's end that poll and have a look at the results. Another encouraging set of results, Ibrahim. Let me leave it to you for your comments. You're muted, Ibrahim.
Absolutely. We've got the A team here. So it'll be good, but it'll be good to know what's been done within these workplaces that the participants have come from. And, if you're willing to share ideas and thoughts on how you've been managing this so positively, please feel free to share that as well, aside from the questions. And I do note there would be questions there. We will take those questions, and Vanessa will guide me as to when to answer some of these questions as well. Thank you.
Yeah, thanks so much. So let me stop sharing that poll. And there's a comment that has come in from Mthimkhulu Mashia, a friend of Conflict Dynamics indeed, and he says, as former Labour Appeal Court Judge President once said, too many workplaces remain dispute-driven rather than relationship-driven. And in the light of this, here's a question for Ibrahim. How can we use workplace investigations as a dispute prevention strategy? That's a big question, Ibrahim. I don't know if you would want to begin with some response now or perhaps park that for later.
No, so I'm going to deal with the first part of it, Vanessa, because of course, I mean, the relationship dynamics and the way the law is evolving at the moment is an important factor. And it may influence a range of things that we need to be talking about. And part of what employers, of course, need to be encouraged to be doing is moving away from this very technical management of discipline, performance, etc. In fact, the Code of a Good Practice that has just come out last year talks about, even from a disciplinary perspective, conversations and discussions that needs to take place. In fact, the cases that we're going to be looking at now also emphasizes the importance of this human component that needs to be given life into our processes. And I think it's a very valuable point. It in fact touches on the components aside from the technical way of looking at constructive dismissal and ill health. There's certainly this human component, and it is the core crucial component that we sometimes forget. All right. But from an investigative perspective, I'll come back to that. If the point is not addressed, of course, we'll reach back to this point. Now, if I may just continue, because of course, there's the decision of sorry, I'm just getting my screen sorted out here. The decision that came through in Lewis versus the CCMA, this is in 25 November 2025, presented what we'd look at technically a contrasting view. In fact, Maleka came afterwards, so Maleka may have been more in what would be looked at the surface level in contrast to the Lewis decision. Because at the surface level, in the Lewis decision, the courts, in fact, said, you know what, it's okay, you didn't use the grievance procedure. But of course, there's a nuance, there's a particular context. And this decision is also a decision of the Constitutional Court. In Lewis, the employee also resigned with immediate effect and did not pursue the grievance procedures. And the decisions were in his favor. Essentially, in the Lewis matter, the difference is the employer abruptly terminated a remote working arrangement. Now, this employee had an arrangement in place that went back to sort of the COVID times arrangements. The employee had actually even moved to another province, and the employee was then ordered to return to the office to start work. Now, the court noted, of course, that employers can make decisions that are reasonable and lawful and that go to their own operations and what's required from an operational perspective, which means that there's no absolute bar to asking employees to return to work. However, in this particular case, what was different is what the employer did in managing the situation. So when it came to Lewis, the employee had submitted a medical certificate. Of course, there was this necessity to return back to the office. But in the medical certificate, the employee was diagnosed with anxiety and depression. And what happened is that the HR initially, through their systems, approved the sick leave. And then suddenly and abruptly reversed the decision and accused the employee of malingering, withheld the salary, which was an important component, and threatened her with disciplinary action, and essentially did not apply any of its own internal processes. Now, of course, when we just hear that, and that's without the details, it's the general description of what had transpired, the courts found that this approach by the employer had already judged this employee, the employer had taken a very accusatory stance and had irrationally rejected a valid medical certificate. And the long and short of it is that the employee had breached, and importantly, the words here, the implied term in this employment relationship, which would exist in all employment relationships, of mutual trust and confidence. Mutual trust and confidence. So, and we understand this point. However, this, from a court's perspective, is understanding the component that there is this mutual obligation of trust and confidence. Good faith is as essential unless it's proven differently. So in such circumstances where the employer's conduct effectively closed any realistic prospect of an internal resolution, the employee had only one choice but to resign based on these intolerable conditions. And given that stance of the employer, the courts found that the failure to utilize the internal grievance procedures was effectively reasonable and understandable, and uphold the finding in respect of the employee. The court said that the existence of internal grievance procedures did not constitute a reasonable alternative remedy in these circumstances. And given that the employer's aggressive accusatory conduct combined with the employee's vulnerable mental health, and expecting her to endure a grievance process was deemed objectively futile. So the employer's actions had already irreparably breached an implied duty of mutual trust and confidence. Now, mental health issues we see now intersecting with constructive dismissal. And there's some important lessons that we can draw from this case and the next that we're going to be talking about from an employer perspective. Mental health issues, particularly stress and anxiety, are increasingly becoming central to constructive dismissal. And it's very important to understand how to manage these issues. So the employer should be very careful before discarding a medical certificate establishing what is the state of the illness of an employee. And the other factors that we need to be looking at. In Sanlam Insurance versus Mokomatsi, the court emphasized that employees must demonstrate that the employer was actually aware or should have been aware of the mental health condition. And this is an important component, which we've mentioned before, that the employer must become aware of this, the illness of the employee. And in this case, the court overturned a finding of constructive dismissal because the employee had not raised his mental health struggles during the underlying CCMA process. So there is still an obligation on the employee. You need to inform the employer. In which case, in this particular case of Lewis, the employee had informed the employer. And for this reason, the employer was under an obligation to then assess that, but could not discard the medical certificate that was already provided. Essentially, the legal protection of having an internal grievance procedure as well, this is an important component, vanishes if, as in the case of Lewis, the management team acts with hostility and baseless accusations towards an employee's mental health crisis. So we've got to be very careful. As management, do we ourselves create a situation that would stimulate, that would enhance the claim for constructive dismissal, that where the courts would themselves find that the employee's necessity otherwise to use the internal processes were themselves frustrated by us, and there was no need, there was no opportunity for the employee to utilize these grievance procedures. Secondly, what this case establishes is that it's important to accept the medical certificate. There is a process to verify medical certificates, and that needs to be followed very carefully. It cannot just be on the face of it discarded. And importantly, dealing with employees compassionately is quite critical. Now, in this next case, we find that the employee, Mr. Nell, was diagnosed with autism and a major depressive disorder. Specialists provided formal guidelines on how he should be reasonably accommodated. It dealt with flexible hours and sensory adjustments. What the employer did here is they ignored the reports. They demanded further internal medical testing without justifying why the existing reports were inadequate. And instead, what they did, they forced the employee into a performance improvement plan. So here again, the employee has a medical report, but more so, it has specific recommendations of how and guidelines of how the employee needs to be accommodated. In this case, the employee approached the labor court to interdict the employer from proceeding with this performance improvement plan. And the court granted the interdict. And we know that the labor court doesn't easily grant interdicts in such matters. Medical testing is inherently intrusive, as we know in terms of Section 7 of the Employment Equity Act. And it is not possible to legally performance manage an employee out of a documented disability without first establishing a settled accommodating framework. So what this simply means, what the court was saying, is that the employer provides you with the report. You then need to accept that report unless there is a basis for you to doubt it. Then once you've got this report, you need to move into the phase of how do we accommodate this employee. So essentially, the ill health process needs to be followed through. And that is the four-step process: investigate, consult, accommodate, and look for alternatives. Now, from a perspective of what we see in from the courts, it is important that businesses, employers have a process in place where their management understand how to read medical certificates, to understand the levels of authenticity, where there is doubt, to understand what to do in those circumstances. You cannot demand that an employee goes for an alternative test, force an employee into a medical test, and we understand that. But if an employee provides reasonable proof, that must be accepted on the face of it, and you cannot just discard it. And this is quite important. The grievance procedure must be followed, and it's very different as compared to the incapacity processes. They are distinct processes. When you're dealing with the incapacity process, there is this follow-through of investigation. So when you receive the certificate, of course, go through the investigative process. There's a necessity to consult with the employee, then consider reasonable accommodation, and then to consider the alternatives. What we're finding, of course, is that this lack of management of whether it is the grievance procedure, the lack of management of ill health certificates that are coming through, dealing with employees' concerns from a mental health and mental wellness perspective, in effect creates the risk for claims of constructive dismissal. So it is important that employers do not cross the line. Clearly, conflating incapacity with misconduct is an issue and a red flag. Just simply discarding employees' concerns on mental health and mental wellness when you have medical certificates, the courts would look into that, and it then establishes a basis for an employee's constructive dismissal claim. Importantly, the performance improvement plan must be utilized for what is put into place and should not be weaponized just to simply to get rid of employees. And I'm going to be wrapping up just with a few tips and leave a few minutes, Vanessa, for some questions. But just from a tip perspective, having read through all of these judgments, and hopefully I've shared some insights, and they're quite a bit. And I did tell Vanessa before, when I took on the topic, it's like I just went down a rabbit hole, and I feel like I have too much information. I'm trying to distill that in a very short period of time. But what is the defensive checklist? Firstly, check your grievance procedures. For a lot of businesses, we advise them to review and refresh their grievance procedures. Consider introducing workplace mediation. Enhance this. People need to be trained, understand how to utilize the grievance procedure and its importance. And it's the strongest shield against constructive dismissal. Importantly, management should not create situations which allows employees to bypass internal processes. Audit your sick leave verification procedures. There must be a process to verify, and we need to understand what to accept, what not to accept. What can we do in terms of referring employees to alternative medical, uh, I suppose, diagnosis? Document the hardship. If you cannot accommodate an employee, document the exact operational financial reasons why. If it if it's too difficult, simply because it's hard to go through the process or it's too complicated, that's not a defense that's going to stand in court. You need to provide actual facts and details of why it's not operationally or financially sound to rejig your workplace and accommodate an employee. Recognize mental health as an important hazard, and the statistics are scary. We need to be addressing this, and I think we're no longer proactive, we're going to be reactive in a lot of workplaces. Training, capacity building, dealing with the complexities. I gave the example at the start of how AI is influencing behavior. And people have relationships with AI in the sense that they would trust the AI more than the manager or the HR person. So in a room, sometimes you're not only engaging with the employee, they're disconnected from you. They are trusting and speaking to the AI as well. These are complex situations, and we need to understand how to deal with it. Importantly, and that's the lawyer part, document everything, keep clear track records. Accommodation is important. You need to address that you need to address that before resorting to any performance or conduct related process. As we've said, exhaust the internal remedies, and we need to assume good faith. And that's hard to do, I understand. But there are particular employers that are problematic, and those can be dealt with quite differently. Vanessa, that's my presentation. And I know I've tried to short circuit it, but I'm sure there are questions or comments, and maybe you want to come in with particular points as well.
Yes, indeed. We've got quite a few questions that have come in. So thank you so much, Ibrahim, firstly, for that insight. It was, as much as you talked about a rabbit hole, I think it was short and sharp and extremely insightful. And I hope that there have been a number of practical takeaways for our audience. But we've allowed some time for Q&A. I'm not sure we're going to get through all the questions that have come up within the last 2 minutes or so. But there are a few that are of particular interest, I think. And one of them reads as follows. If we are requesting disclosures of medical conditions, is that not in conflict with the employer's right to the employee, I assume it should mean right to privacy? And it says here, I'm asking because medical practitioners use the term medical condition a lot.
Yeah, no, of course, absolutely. That is well established. We cannot violate that. The employee has the right to keep their information secret, but of course that needs to be documented. If an employee is not willingly contributing to providing the information, then the employer can't deal with the matter as an ill health issue. They now don't have any information to establish that there's an ill health issue or mental health issue, and they'll have no option but then to deal with the matter as conduct performance.
Excellent, thanks. And then I think it's actually a related question from the same attendee, where it says that GPs also manage and treat conditions like anxiety and depression. So would a medical condition certificate and proof of collection of a prescription not be sufficient in these matters?
So this is an important point, and I think it's a part that I've skipped. For management, they need to understand how to read that. If it's insufficient or they have some doubts, there's a process of investigating. And I think that cannot be skipped. We cannot just in isolation say, well, oh, this, I don't like the certificate, it doesn't make sense. You can inquire, and there are limitations, I understand. GPs may not give information without the permission, but sometimes the GP doesn't even exist, or there was a fraudulent sick note. So you can do whatever investigation that is possible, and that's a requirement. And you can also call the employee in and engage them into the possibility of providing more information. There are limitations to all of this, of course, but there would be a necessity to investigate before simply discarding a certificate, because the medical certificate is proof of a medical condition on the face of it, whether it's a GP or a specialist, etc.
Thanks, Ibrahim. Dave has posed a question, which I must say, in my experience with many, many different clients, they have this particular ongoing issue, and it's around the length of time that sometimes an incapacity process stretches on for. So Dave has said that employees are on excessive periods of absence. Employers are afraid to effect the incapacity process. I mean, I assume, Dave, you mean bring things to a conclusion. So his question is, can the employer be expected to continue with this unacceptable circumstance?
Of course, I mean so ideally, in an ideal world, the diagnosis, it's understood and there is reasonable accommodation. So there should be a plan that's accepted and put into place. The employer can consider its operational needs, the financial circumstances, what's available to accommodate the employee. Leave, whether paid or unpaid, is also an accommodation. I'm not talking about sick leave, because usually the sick leave is used up and there's a necessity to utilize other leave. But also, furthermore, if the employee again needs to participate in how much time is required, what's happening in that period. So there must be clarity. And I hear Dave's point. As soon as these issues, whether it's on illness, mental health, discrimination, raise, management become quite fearful. And part of what we raise in here today as well is the empowerment to deal with these things. Because employees can manipulate situations. I'm not saying in every instance, because these are trigger words, and then we back off and we take more time. We don't know what to do. So it's a good idea to get good advice when you're faced with some of these situations so that you know how to deal with them. There is no necessity to sit back and just wait through this.
Excellent. There are a number of comments and questions that have related somewhat to the work from home dilemma. So I want to just pick up on one that specifically relates to this ill health dilemma, mental ill health. And so Goetze Mang has asked, how do we handle a recommendation of an employee needing to work from home? Can we deal with that as overreaching?
Well, again, it depends on the type of work. If this is, we've got to look at what is reasonable accommodation. And we're assuming now there's a necessity for the employee to work from home. And can that be replicated in the workplace? What's the implications from an operations perspective? So there's no one answer. I think the requirement again is to be investigate, consider the practicalities, but this needs to be dealt with in detail and they must be recorded. And once you've come to a conclusion that's sound, balancing the operational needs versus the personal needs, you're going to get to a decision. So not just simply, okay, it says work from home, we're going to accommodate. That's not what is required. You still need to institute what would be necessary from a business perspective as well.
Yeah, yeah. Sadly, we've really reached the end of our available time on this topic. I have a sense that we could carry on for at least another half an hour. There are so many questions here, and it goes without saying that we apologize for not having the time to get to all of them. But thank you so much to everyone for your active participation and your interest. Thank you, of course, very much to you, Ibrahim, for your time and your insight. And I'd just like to mention that we, of course, at Conflict Dynamics focus on this particular area in our training packages. And we would welcome the opportunity to discuss any need that you may have for assistance with your training. We have dedicated workshops on the topic of dealing with incapacity, including mental ill health. And on that note, I look forward to welcoming you to the next coffee meeting in a couple of months' time. And until then, stay warm and stay safe. And thank you very much for joining us. Bye bye,
Thank you.
everyone.
Bye bye.